yourself thanking the storm, 'cause the floodgates have opened. You let go of standing on the edge, for the future's holding. Hear your prayers turn from begging God to praising Him. As you find it, He's always been much closer than the air you're breathing. So breathe in, my friend. This is not a breakdown, it's a breakthrough. This is not a midnight, it's a brand new morning when it dawns on the dark. No, this is not the moment when it all falls apart. It's a beautiful place to start. It's a beautiful place to start. The hardest part is the letting go, and sometimes it feels impossible. There's still love in your arsenal, if there's still blood in your heart. The hardest part is the letting go. Sometimes it feels impossible. There's still love in your arsenal, if there's still blood in your heart. You see, my friend, this is not a break. This is not a breakdown, it's a breakthrough. This is not a break. Oh, it's a brand new morning when it dawns on the dark. No, 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 this is not the moment when it all falls apart. It's a beautiful place to start. Beautiful place to start. Beautiful place to start.
Feels like I won the lottery. Didn't have to pay a thing. When love is real, it's really free. Feels like you knew me all along. You wrote the lyrics to my song. I wanna sing it on and on. Why would I ever go back? Would I ever go back? Oh, now that I know what I have, never gonna look back. 'Cause life with you is more beautiful than anything I've known before. Life with you is like living every day in a brand new world. Loving you is easy when you love me like you do. It's not hard to choose, spending my life with you. When you took my hand, you stole my heart, tore insecurity apart. 'Cause I didn't have to hide my scars. Why would I ever go back? Would I ever go back? Oh, now that I know what I have, never gonna look back. Yeah, life with you is more beautiful than anything I've known before. Life with you is like living every day in a brand new world. Loving you is easy when you love me like you do. It's not hard to choose, God of beauty and God of grace, oh God of glory and endless days. The heavens formed when you spoke their name, and by your hands the earth was made. Oh God of all things good and true, no height, no depth is unknown to you. Lord of all, yet you know my name, and in your image you say I'm made. Oh, your light shines in the darkness. Oh, your grace gives hope to the hopeless. Oh, your beauty abounds in my brokenness, and I'm made new again. God of all my anxious fears, when all hope seems far, won't you please be near?
Just got it in the back. Yeah, please. Awesome. Well, thank you so much for attending this evening. My name is Daniel Leonhardt. Danny is what I'm called by most friends. But this evening, we're going to talk about how wills work, how trusts work, and how they're different. What's probate? How do we avoid the probate process? What triggers a probate here in Virginia? We'll talk about that. We'll talk about what happens if you don't have a plan. You know, the I'll get to it someday plan. What if you have just a last will versus a revocable living trust? What's the outcome to my family if I do this versus that? So we're going to lay out different legal options. Why? So that you can make the right choice for your family. It does say in Proverbs, a good person leaves an inheritance to their children's children. So even it talks about this in the Bible. Money is one of the subjects that is talked a lot about in the Bible, as a matter of fact. And we know that God does not have a problem with us having wealth, but he does have a problem with wealth having us. So again, it's all about perspective. It's understanding that we've been very, very blessed. So what do we do with that? I've been attending here since 1999. Some of you might know me from that, but I'm sure most of you know me from, here we are. My big screen debut with Jonathan. We did the Feeding of the 5,000, so there's my wife and I. Anyways, it was a great time there, but no, just let's get back to what's serious here. My daughter said, you should do it again. I said, no, I did it last time. That's all right. These are new people. They won't see it. Sorry. All right. I am going to go 1 hour, and then I'm going to stop for questions. Those that need to scoot. 7:30, you're out. But I will stay as long as it's necessary. They said I can have the room till 8 if needed. So, all right. Let's talk about this. We all have wishes and wants. You know, I don't want my kids to fight, or I don't want my son-in-law to get anything. I like to remind people that, listen, what you want and what you get is going to vary based on what you do. We have the ability through great documents to orchestrate and make sure that wishes aren't just wishes, but they become realities. So we can do that through great documents. Over the many years, people have asked me, what is estate planning? I don't have an estate, you know. They think English countryside, some rolling hills, a big house, you know. I say, well, there's 3 kind of basics planning that people do. There's financial planning, that's not this, you know, growing your wealth and investing. If you do a decent job with that, you can do the next planning, which is retirement planning, where you say, I don't want to work forever. I want the money to work for me at some point, right? So you plan towards that too, right? And then there's the third planning, which is estate planning. And really, estate planning is just making sure that all that we've accumulated in this world goes to the right people at the right time without fighting, without the courts, and without the probate mess. And that's the goal of a good estate plan. Well, let's talk about options. Some people's estate plan consists of this. Every year you say, well, didn't do it last year. I'm going to do it this year until next year when you say it again. And it's just a series of kicking it down the road. You know it's important, but you never quite get to it. Well, folks, if you die without a plan, and I mean no will or no trust, that is called dying intestate. And folks, when you die without a plan, you do get a plan. It's called a government plan. And the state in which you died, in this case, the Commonwealth of Virginia, is going to create a will for your family after you're gone. Now, this new government-written will has to go through a legal process called probate, where the assets will be tied up in the courts, and the family has the opportunity to get together and argue over the things you left. Now, folks, there are 2 things that I am pretty sure you do not want. You do not want to send your family to court, and you do not want the government to write your will. Now listen, when the state writes the will for someone who died without a will, you have to understand, the state does not know any of the family details. The government doesn't know that Susie already got her inheritance, Jimmy hasn't talked to Dad in 10 years, and Barbara never paid back those loans. But you know who does know the family details? The family knows. So when they get together in the courtroom, it sometimes sounds like this. Your Honor, yeah, this will you guys came up with? Not even close. She shouldn't get, he already got, mom wanted me to have, and guess what they wind up doing in court? They wind up fighting. And do you know who wins that fight? Besides some local attorney in the state, who often wins that fight is just the person that hired the better attorney. You know, Jimmy, the more clever son, hired a good lawyer, and when it all shakes out, he winds up with more of the estate. Now, the worst part about letting the family work it out is very often the end result of that is they don't talk to each other. And I'm sorry, that sometimes lasts for decades because of what she got away with or what he tried to get away with. I will admit this, folks, the do nothing plan is the least expensive plan available for you today. But it is the plan that will cost your family the most time, money, and aggravation. So make a commitment not to me, but to yourself that I'm not going to leave this earth without something in writing. I need to have something put in place. That being said, what can I do to prepare for my eventual departure? You could do something called a last will and testament. Now, everybody here has heard of a will, and some of you no doubt already have a will. Let me remind you what a will is. A will is basically a set of instructions that says something to the effect, when I die, I want these things to go to these people. But what you may not know is your will, when you die, has to go through probate. Whether you write the will or the state writes the will for you because you didn't, wills have to go through the probate process and go before a probate judge. Now, I'm going to mention the word probate a few times this evening, and I thought you might want to know where the word came from. The word probate comes from an old Latin word, and the Latin word, the root word, is probare. Now, the word probare meant to test or to prove or to challenge something. What is being tested or challenged in the probate process very often is the will itself. Someone doesn't like what mom wrote, and so they come to the court to contest the wishes of the deceased. Now, when someone contests a will, they don't say, Your Honor, it's not fair. I thought I was going to get more. He'll say, sit down. You have to give the court some reason to throw doubt on the document because you're asking them to not follow it. So you have to give them some sort of reason. So some people will say something like this, Your Honor, that doesn't look like Dad's writing. I know that's not what Dad wanted. I think somebody drew this up after he died. You know, and the accusation, it's a false document, not even true the intention of the deceased. Another angle of attack might be this. Your Honor, Mom was saying all kinds of crazy stuff at the end. I don't think she was mentally competent to draw up the document. I can bring witnesses that will tell you some of the stories, you know. And so they're throwing doubt on the mental veracity. She was not of sound mind. Another one might be this, Your Honor, all of my life I was told I was getting this property. I saw a will that says I'm getting this property, but this new document suddenly appears giving everything to her. I think she talked Mom into changing it, and the term you hear here might be undue influence. She was the caretaker, someone in charge of medication and food, and suddenly something changes and surprises everybody. But the bottom line is, folks, a will is not a binding set of instructions. It is a set of instructions, but it can be challenged and changed by the court. Wills are contestable. A will, by the way, folks, does not help us at all if we become incapacitated prior to death. Because, folks, a will does not go into effect until you are dead. So a will is certainly an option, folks, but it is a very narrow option. It only deals with distribution after you're gone. It doesn't help you while you're alive if you're impaired. It doesn't avoid the probate process. It still has to go through the probate courts. And as I said, it is not binding until the court says so, and that's after they hear, you know, this, that, and the other. Okay. There is a better option that's available to all of us. It is called the revocable living trust. The living trust, folks, is a legal document that allows us to transfer our assets to our heirs when we die, but it does so without courts, without probate, without delay, and most of the time, if you do this right, without the family fighting. Because unlike a will that can be challenged and argued about, the instructions in your living trust when you die are binding. When you create a trust for your family, folks, you are in essence saying, Hey kids, here's what you get. Now, listen children, whether you like it or you don't like it, this is what you get. You're getting this asset, this percentage, this property, but it's not subject to debate like a will, that it can be changed when you die with the trust. The instructions are binding. Now, the trust, folks, not only makes a smooth transition of our assets to our heirs without courts and without government intrusion, the living trust does take care of us while we're living, because in the living trust are what we call incapacity documents. Think of this as a portfolio of multiple wishes. This is not a document just about distribution. Certainly it addresses that. Who's going to inherit, who's distributing the assets to the heirs. That's in here, of course. But within here are who's going to step in and care for me if I lose mental capacity, whether it's physical or mental. At some point, someone needs to step in and help. For many of us, that will be the case. And if that's the case, who would we want in those cases? So I'm going to go over those three documents. If you are a married couple, we would likely make a joint marital trust for a client. That's one trust for the two of you. But within that joint trust would be separate powers of attorney and separate advance directives. Are you following me? So kind of an overarching trust, but within that separate instructions so that you don't have to pick the same person your spouse wants to pick. So you can choose different things. So let's go over these. Everybody that's in this gets a power of attorney over financial and legal matters. And that is basically, who do you trust with your checkbook? You know, who would you want to go to the store and, spend the money on your behalf? You know, the person that you would want to make sure that the lights are kept on, the air, all of that stuff. The things that you used to do, you can't do. So you're trusting this person with your checkbook to pay your bills. This person usually has some additional, not always, but additional authority, legal authority, so they can help you in the event you're living in a big old house, leaving the fire on, the kids are freaking out, it's time to move into an assisted living. They may be able to help you sell and change. So there's financial and legal, so that's, in most cases, it's both of those. There's another power of attorney called the healthcare or the medical power of attorney. Sometimes that's called the healthcare proxy. And the healthcare proxy or the power of attorney is just who do you want to interact with the doctors if you're consent to surgery or something like that. I'll just remind you really quick that if you're unconscious, you cannot consent to anything. So you might need someone at some point to evaluate and speak on your behalf, and that's the person we're talking about. Now, the person that you select for the healthcare power of attorney can also be the person you want for finances. It could be the same person with two roles, but it could also be two different people. Are you following me? They're different, distinct roles. So you could pick one person to act for both or separate people. There's a third document within this incapacity section called the Advanced Medical Directive. In the old days, I shouldn't say the old days, it's still sometimes referred to as a living will. Now, a living will is not a living trust, and it is not a last will. A living will is basically instructions as to how you would like to be treated if you're on life support, feeding tube, respirator. We heard the term ventilator too much 6 years ago, 5 years ago. But the concept is you can be in a situation where decisions need to be made. Well, this is you giving insight to the person you selected so they would know what you wanted, right? So the other two are appointing people. This is giving instructions. Think about the three words here, advanced medical directive. Medical, having to do with the medical decision. Directive from the word direction, okay? I would want this. But you got to do it in advance, because when you're in that situation, you cannot. Now, some of you in this room might remember the name Terri Schiavo. It was a girl in Florida, had a terrible accident in her late 20s, and she was in what we call a vegetative state. She was not in a coma, but she could not feed herself. She, couldn't communicate. After a while, Terry's husband said this, well, Terry wouldn't want to live like this. We're going to disconnect the feeding tube and say goodbye. Well, Terry's parents said, hold on, we think she's still there. When we come into the room, she lights up a little bit. So what happened is they went to court. And as you know, in court, there's a winner and a loser, and the loser appeals, and what happens? You go back to court. And if you don't know the story, they went back to court and back to court and back to court for 15 years while she was on the feeding tube. Do you know who eventually decided her fate? The state of Florida. That's right. The state of Florida said, no more courts. We're done. Here's what we're going to do. And of course, one of the parties was a little more happy with that result than the other. Not saying they were rejoicing or happy, but it fell on one side or the other. The reason I tell you that story, folks, is simply this. It is not because Terry had no wishes. Terry might have been adamant, I would never want this. But it is because Terry had not expressed her wishes in writing in time. I'm going to say something that is really true, but it's also a little blunt. And here it is. It's not going to matter what you want. It's going to matter what you wrote. You got to get these wishes in writing. At one point during one of the trials, the husband said, Your Honor, we watched a movie once. She said, I would never want to live like that. And you know what the court said? Hearsay. I have nothing in writing that expresses those wishes. My point is you have to put your wishes in writing. And your spouse does not have the authority to end your life unless you need to assign people, right? They have to act. But I want them to know what I want. You know what I mean? To get an idea of what my wishes would be. So the advance directives is sort of spelling out, if this, then I would want it to play out like that. Make sense? So I like to break words down a little bit. Probate comes from the word probare, to test or to challenge something. The phrase power of attorney, the word power here just means authority. I am empowering you with my checkbook to make sure I'm cared for. This isn't your money, it's still mine, but I'm giving you the authority to pay my bills and make sure I'm taken care of. The word attorney in power of attorney does not mean someone that went to law school. It just means advocate, okay? Now, if you're in a courtroom, you hope your advocate went to law school. But in this case, it's going to be a family member in most cases. Does that make sense? Now, I happen to have a choice that many of you in this room have, and that is I'm a married man, and I've been married to my lovely wife, Christy, for 41 years. She is my power of attorney for finances and healthcare, and I am hers. Does that make sense? We've selected each other. But what if my wife and I got into a bad car accident, and in the accident, I become impaired, but she dies? I now need a power of attorney. I'm impaired. But the person I selected, unavailable. In this scenario, I not only lost my wife, but I just lost my power of attorney as well. So my point is, folks, when you name your first choice, that is my primary choice, always name alternate A and alternate B. Why? You have no guarantee that the person you want will be there. They may not be there. They could be in worse shape than you. So pick a choice and then say, okay, but if not them, second choice, third choice. Now, I happen to have some pretty good alternates. I have 4 adult children. I've got a daughter that can tell you how much money she has in every account and how much she's saving for Christmas. She's married to an accountant. A good choice. So if I cannot be there for Christy or she cannot be there for me, it drops to her. I have another daughter that's a nurse practitioner, wears scrubs and works in a hospital all day with doctors. So when it comes to healthcare decisions, I have a pretty good choice there. If a doctor were to say to my daughter, hey, I need you to sign here for your dad's surgery, you know what she'd say? Great, hold on, let's talk about this. What is this hospital's percentage of success rate with this procedure? What is this doctor's percentage of success rate? You know why? She's worked with doctors and she's worked with good doctors. My point is, I am not looking for someone that says, where do I sign? I'm looking for an advocate. Does that make sense? Someone that would ask the questions that I would ask, right? So you're going to have to think within your family. Obviously, if you're married, you might have a natural first choice. But beyond that, who would I want to do that job? Now, over the many years I've been doing this, I've had people say, Daniel, I don't have a doctor or a nurse, but I have 2 really wonderful kids, and I trust them. And which one should I pick? And I said, well, I'm not going to decide. Those are your kids. You have to decide. But I tell people, if you have 2 pretty equal choices when it comes to the healthcare power of attorney, which of the 2 of them is good under pressure? When the doctor says we need to decide this in the next 15 minutes, that can be pressure, right? You know, they're making a decision for you, right? There's some responsibility to that. They also might be the person that has to tell the rest of the family, I know, I don't want to do this either, but it's what Dad asked me to do. Dad said under this circumstances, we're not going to do any more. Are you following me? They may be the one that has to stand up to the rest and say, I don't even want this. But Dad assigned me to do it, and he put it in writing, so I'm going to honor his wishes. Does that make sense? So you have to think within your family, who would be a good candidate to do that? And when it comes to the financial power of attorney, I'll just say this. If your son is really bad with his money, he'd probably be bad with yours. If his money's confusing, imagine adding yours to that. So again, think, you might have to go outside your immediate family. You know, it might be you don't have children that would act in that way. I don't know, but you need to think of who, because it's important. When you don't, the courts will. And they may pick the one most eager, but not the best. So, you know, all right. Okay. Now, a lot of people have heard that the living trusts avoid probate, and that's true. But a lot of people don't know what probate is, other than they heard that they don't want it. Let me describe it briefly. Probate is a judicial process where when someone dies, the state, through the courts, they have to verify and validate any wills to see if they're current, relevant, up to date. They have to settle family disputes. They have to pay the debts of the deceased. And when all of this is over, eventually assets do get distributed, but that's at the end of the probate process. There are two major misunderstandings about probate, and here's the first one. Some people think, now they're wrong, but they think that a will gets you out of probate. And their logic is this. Well, geez, I've written down what I want, and it's signed and notarized. And I say, that's fantastic. But it still has to go to probate. Now, there are multiple reasons why the will has to go before a probate court, but I'm going to give you one right now. A will does not always represent the wishes of the deceased when they died. Now, folks, we assume it represented your wishes when you wrote it. You know, I want this and this is going here. But after someone writes a will, sometimes things change, and people change their mind. I had a guy come to my meeting once. He said, Daniel, I've got a will. He said, I wrote it 15 years ago. He said, the will gives everything to my wife, Kathy. He said, now the only problem with that is I've been married to Susan for the last 7 years. He goes, Kathy was my wife 15 years ago. She's now my ex-wife. I said, and according to this piece of paper, the beneficiary of your entire estate. You know what the legal term for that is? Whoops. I had someone come to my meeting not long after, and she goes, oh my gosh, you just reminded me my ex-spouse is still on a couple accounts. I was busy getting divorced, I forgot about those. People have out-of-date wishes. And if you don't clean it up, somebody else does when you're gone. Now, the second misunderstanding about probate, some people think a will is enough to avoid it. Nope, a will has to go through probate. The second misunderstanding is some people think they don't own enough. And they say, well, maybe rich people have to deal with that. I just have a house and a couple kids and a pretty simple situation. Folks, you do not need to be wealthy to trigger a probate. Now, I use the word trigger because it is a dollar amount, and the amount that triggers a probate in Virginia is different than the amount if you move to North Carolina or the district. So there's different triggers. Basically, the state says if you own less than a certain amount, when you die, your estate triggers the if you own less than a certain amount, your estate skips probate. But if you own more than this when you die, your estate triggers the probate process. And here in the Commonwealth of Virginia, folks, that dollar amount that triggers probate is $50,000. That's it. So your home, even a lousy home, is worth multiples of that, okay? So $50,000 triggers probate. Now, that's if you die in Virginia. If you were to move to North Carolina and die, it only takes $20,000 to trigger probate. If you, not that you're going to, but those that live in the District of Columbia, it only takes $40,000. Now, what can you own in D.C. for $40,000? A parking spot? I doubt that. It's an incredibly low threshold in most of the states. Maryland's also $50,000. there's not a house I'd want to live in Maryland that would be worth less than $50,000. So they're all quite low. Now, over the many years I've been doing this, I've had people say, Daniel, that number doesn't sound right. I think I remember it used to be 650,000, then it went to 675,000, and then it went to like 1 million. And I say, I'm sorry, that is never what triggered probate. But that used to be, back in the 90s, what triggered federal estate tax, which is different than probate. Now, if you don't know what federal estate tax is, it's something like this. The government says you died with too much money, but don't worry, they're going to help you out. They just start taking your money. Now, once you hit the trigger for the federal estate tax to hit, what they usually hit above that is 40% goes to the government. So it's all, thank you for working so hard. We appreciate that, We got some programs in Peru we got to, anyways. So let me give you a quick history lesson. This won't take long. 1999, the number that you could give tax-free. Isn't that funny? How long has that money been taxed? All right, we're not going there. You could give $675,000, and then they would tax after that. In 2000, it went to $1 million. A few years later, $1.5 million, $2 million. I'll just tell you right now, folks, 2010, that was the year to die. There was no federal estate tax for 1 year. That's when Steinbrenner died and gave the Yankees to his family. Good timing there. In 2011, it came back at $3 million. It has gradually gone up since then, and today the number is 15 million. So I'm going to assume most of you are just under that 15 million. You don't own enough to trigger federal estate tax, but you do own enough to trigger probate. Are you with me here? 50,000, 15 million. Now, I'm going to give you a tax example. One of the things we put here is tax advantages. I'll give you a tax advantage to this, but it may not affect you at all. It might, but it may not. Today, the federal exemption is 15 million, but because my wife and I did this together, that's two people creating a trust, we get to double that to 30 million. It's not a problem at 30 or 15. We're not anywhere near there. But let's say some future government, someone that's, sad, but anyways, says, you don't need more than $1 million. We're going to reduce it down to $1 million and we'll tax everything over that. At least my wife and I can double that to 2 million because there's two people that did it. Are you with me? So don't wait till you're, widowed or widower. If you can while you're married, do it because we don't know what the number will be when we die. I just know it's ×2 for us. So again, that's an advantage. May or may not need it, but it is an advantage for a married couple. All right, so a will doesn't get you out of probate. You certainly do not need to be very wealthy to trigger a probate. What's so bad about it? Well, I'll tell you, I have done this workshop you're hearing tonight all over the state of California, Arizona, Tennessee, Texas, all up and down the Atlantic. I've been in a lot of churches, but a lot of just outside secular environments. It doesn't matter what state I'm in, people don't like probate. And I'm going to give you the 3 big reasons people don't. There are many reasons, but 3 big ones. Probate takes a long time. It costs a lot of money, and it's a very public affair. Public courtroom, public documents, everything is out in the open. Let's take those one at a time. How long does it take in a state to get through probate? National average is 1 to 2 years. I will tell you here in the Commonwealth, 1 to 2 is common. The longest probate I ever heard from someone at a meeting, lady, I was in Culpeper, you know where that is, about an hour west of here. Lady comes up after my meeting, says, Daniel, I'm not sure how long Mom's probate actually took. She goes, after 10 years, I told the family I'm not coming back to the courtroom. She said, I'm done with all of you. You can do what you want with my share. I'm done. And then she leaned over to me and says, Daniel, I think by then the lawyers were getting most of it. Could you imagine the legal fees of fighting in 10 years in court? Just before COVID, I did a meeting in the district. This lady comes up after, she goes, they say it's going to be over soon, but we've been 5 years in probate. Nothing's been distributed. Everything's still tied up in the process. Now, let me make this really clear. 5 years and 10 years are not that common. They certainly happen, but 1 to 2 is very common. That is the typical. That's still a long time. Assets are frozen and money can't be divided. Here's the second problem. It's expensive. There are the attorney's fees, court fees, filing fees, assessors, sometimes accountants get involved. There's a Virginia probate tax, and many counties, they got their hand out too. They say that if nobody fights or argues, the national average of what is lost in probate, meaning here's the amount they died and here's the amount that got distributed, the cost going through probate, the national average is 8 to 10% of the gross market value. Now they say in Virginia it's a little lower than that, yay, but they say it's more like 6 to 8. So I don't know what that means to you because I don't know what you own, but let me throw out some numbers. Let's say that your primary residence was a little condo and it would sell for, I don't know, $300,000. I know you have to use your multiplication tables here, but let's just say your residence was 300. Everything else was another 100,000, investments and antiques. And so your total estate in this example is 400,000. 8% of that number is 32 grand, folks. That's a lot of money your kids won't see. And that's, I'm sorry, that's if they don't fight. I will remind you right now, if Susie hires a lawyer because Jimmy hired a lawyer and they go at it, it can get way worse. So probate is not only a lengthy process, it is an expensive process. Here's the third problem, it is very public. Did you know that when you die with just a will, folks, your will becomes a public document and anybody can read your wishes? Nosy neighbors, ex-spouses, disgruntled family members, but not just read your will, anybody can also contest it. Again, not all wills are contested, of course, but usually when they are, it's family, you know. Why is Jimmy getting the boat? Grandpa promised me the boat. Well, at the end, Grandpa promised everybody the boat. You know, the wheels weren't spinning like they used to. By the way, I've heard a lot of stories about probate over the years. One of them stands out. This one guy said this to me. He said, Daniel, I knew when we got to probate court my sister was going to lie. I knew that. He said, I just didn't think she was going to lie that much. She kept going on and on. Your Honor, this isn't fair. And Mom really wanted me to have that. And I know that's what the will says. But when she was doing the will, we were having a fight. He said, I finally had it up to here. And he said, I blurted out in the courtroom, Mom would be spinning in her grave if she heard you. That's not true. He just called her out. The judge said, would you please approach the bench? So the judge invited the two of them to come up. And he said, listen, here's my recommendation is that you go out in the hallway and work something out. Because he said, right now, you are giving your mom's money to these attorneys. And he said, if you haven't noticed, these attorneys are in no hurry to get out of here. They have an incentive to make this drag on and to make it worse. And that's not good for you, but it's good for them, which is sort of a sad incentive to do that, but it is. So if you think about by the way, when there is a fight, very often it's not your kids that started the fight, it's the ones they married. It's the daughter-in-law who says to your son, how come she's getting that? And next thing you know, he's not talking to his sister, but the lawyers are. Think about the dynamic. Sometimes it's, it's a lot of money. Sometimes it's all of a sudden, didn't expect sudden death. It's money, it's family, it's in-laws, it's expectation. I thought I was going to get that. And then it's opportunity, and all of that is a perfect storm. I've heard a zillion stories about probate. I will tell you, probably 7 out of 10 start with a line like this. Daniel, I never thought my family would act like that. And then the story proceeds from there, So it's just very, very sad. But as I said, your will becomes public. Some of you in this room might remember, this is a young crowd, maybe not, Charles Kuralt. He was a CBS reporter. He had a show years ago, On the Road with Charles Kuralt, Sunday mornings. Well, he died about 25 years ago, and when he died, we discovered he was not alone on the road, apparently. The article says, woman lays claim to the Kuralt property. The article goes on to say, Charles died with just a will. As his will was going through probate, a woman showed up and said, Your Honor, Charles and I had a long-term affair, and I'm entitled to some of this. And she said, Your Honor, I can prove it. So out come the love letters and handwritten notes and receipts. We call that evidence. Today it would be text messages and emails, right? You could ask Tiger Woods or General Petraeus, I guess. But what did the court do? Well, they listened to her claims. They looked at the evidence she presented. The article goes on to say, then the court awarded her the ranch in Montana, all the buildings on it, and other property. When I read that, my first reaction was this. Why would the court do that? She's not even mentioned in his will. But remember what I said earlier, your will is a set of instructions, but it is not binding, and wills get contested and often changed. So, well, folks, that's a lot of bad news. I got good news today. Besides the good news. The good news about this subject is you don't need to have a probate. When you get a revocable living trust, the first benefit is no probate waiting for your family. So instead of your assets being tied up in the court system for a year or more, literally within days of your passing, assets are available for distribution. I mean, while people are in town for the funeral, assets can start to be distributed. Now, I'm not going to shock you when I tell you this, but did you know that I happen to have a revocable living trust? So do my brothers, so do my sisters. When I die, the family will all come to the funeral. Section 2 says they have to attend. My son will then grab the checkbook and he will go to the bank. He will go to the bank and say this. He'll say, oh, that's not it. He'll say, my dad died last week. Here's his death certificate. And here is, my dad has 30,000 with you guys. He's no longer with us. And here is his trust. My father's trust says he's the trustee. My mother has already passed. I am Charles, the successor trustee. Think like executor. I'm the original trustees. They go, successor trustees steps in. The bank says, okay, Charles, you prove that your father's no longer here. Can you prove that you're Charles? I need to see some ID or something. So he presents the ID. The bank then turns to my son, says, Charles, what would you like to do with this 30,000? Now think of what I just said. I died last week. Monday's the funeral. And Tuesday, he says, 4 checks, please. Here are the names. And he closes the account. He calls his sisters over and says, here's the money from Dad's Truist account. I've got 2 more accounts I'll be getting later this week. You guys can come back next week. By the way, while I have you here, who's going to help me get the house ready? I've got realtors coming on Monday to interview. You know why? There's no probate. There's no delays. We can start the process now. But what if I died without a trust and I died with just a last will? Well, they all go to the funeral. Next day, Charles goes to the bank. And Charles says, look, my dad's got 30,000, would you guys? My dad died last week. Here's his death certificate. And here is my father's will. His will plainly says, I, Charles, am the executor. Can I have the money, please? And you know what the bank says? I'm sorry, Charles, but this account is now frozen until the will goes through probate. Because a will is not valid until the court validates it. Now, let me give you one reason why. And you may not have thought about this a half an hour ago, but think about this now. Every will you've ever written, if you've ever written a will, says last will and testament. Nobody listening to me this evening wrote first will, second will, third will. No, they all say last will. How does the bank know if they're looking at the last of the last wills? There might be 2 more out there. They don't know, so they freeze the account. But with the trust, access right away. Instead of your family losing tens of thousands of your hard-earned dollars in the cost of going through probate, whatever you spend on a trust, folks, is going to be a lot less expensive. Now, I'm not going to shock you when I tell you this, but did you know that attorneys don't do this for free? You can find a lawyer, sit down in a nice leather chair, tell them what you want, and have a trust made. I'll just tell you what people tell me. Daniel, we spent, and I usually hear a number today between 4,000 to 5,000, sometimes more than that. We do this for a lot less. Part of the reason is, workshops and groups and stuff like that. But still, let's just say the number was 4. Let's just say that's the number, 4,000 to get a trust. Again, we're less than that, but let's say it was 4. What's 4 compared to 8% of the gross market value? Gross, not net, not equity, gross market value. You're talking tens of thousands, maybe 100,000, or an investment of 4,000 or 5,000. So I'm just saying that's an example. So time is reduced to days you can start. Cost is reduced to whatever you spent here, right, to avoid that. And the third benefit of a trust is the privacy, which I think I've named more privacy as the second answer here. When you die with a will, folks, your will becomes a public document. Anybody can read your will, nosy neighbors, ex-spouses. It's a very public document. Now, when somebody dies today, usually Something shows up in the paper a week later announcing the death, called the obituary, right? You've all heard of that. So-and-so died, survived by so-and-so, loved to woodwork or whatever, something about your life. Something else shows up in the paper a year or two later, and it's the announcement for probate. I brought a few examples up here. It's where, the small paper, not the Post. We're talking the paper that has the yard sales and the basketball score from the high school. But these will have, notice, legal notices. The print gets really tiny here. I'll give you just some examples here. There's 3 headlines in each one of these court notices. The headline is in bold print, capital letters, and it says, "Notice to any creditors, notice to any unknown heirs, notice to all persons interested in the estate of," and then there's the name. So who was just invited to probate? Anybody. If you can Google, you can get interested. But after that are 3 points: the name of the person who died, when they died, and if they had a will or not. This is a little bit older. This is a 2022 paper, think 4 years ago or so. This person died in 2019 with a will, 2018 with a will, 2020 with a will. I could go on and on. This one's, I didn't print these, by the way. These are newspapers, but this one is a 2020 paper, so think COVID here. 2017 with a will, 2017 with a will, 2019 with a will. But this person died in 1998 without a will, and they're still in probate 22 years later. Folks, that's pretty public, right? Everybody's invited to find out how much you had, who's inheriting, how much you owed. Well, all of that is public. But let's contrast that with the trust. When you die with the trust, there's no probate. And the only people that can see the details inside your trust when you die are your named beneficiaries. And that's it. Not nieces, not neighbors, not ex-spouses, just the people whose names have been printed in, as beneficiaries. That's one of the many reasons, folks, why Susie Orman, Wall Street Journal, Forbes magazine, they're telling you you want a living trust. I have an article here from Modern Maturity magazine. If you look forward to going to the dentist or paying taxes, you might like probate. Probate's costly, slow, outmoded, a sad state of affairs. Trusts, however, are a valuable estate planning tool. Some of you might be familiar with Susie Orman. She wrote this a while back. Regardless of how much you do or do not have, in most cases, a will is not enough. You'll also need a revocable living trust with an incapacity clause. And that, again, is the powers of attorney, the advance directives. That she wrote in 2004. Here's a more recent article. In Trusts We Trust, of course, I love the play on words. Let me read you one line. It says, wills are required to be approved by a probate judge. But with a revocable living trust, your estate is dispersed exactly as you laid out in the legal document. No need for your heirs to get court approval. So I just want you to know there are more people than me telling you about this. You can read a lot of articles. Our website has quite a few on there. All right, we talked about the do nothing plan. I don't recommend that. A will is certainly better than nothing. I want to acknowledge that. Better to have something in writing than nothing. But by far, most people discover the trust is a much better option. I want to bring up one more option, and I'm going to try to do this in about 4 minutes. I want to talk about the dangers of joint tenancy. Most couples own assets together, right? Jointly. One dies, who owns it? The other. There is no probate when the first spouse dies. But eventually, the second spouse dies. And then there's probate. What happens if the couple that owns the asset together dies together? A car accident, some sort of COVID thing? Instant probate. There's no one left on the title for it to fall to, so it then has to go to probate. So just so we understand the basic rules here, joint tenancy doesn't solve your probate problem, it just postpones it. Are you with me? Till the second one goes. Some people think they've come up with a shortcut. Here's what they say. Well, now that my spouse is gone and I own the assets by myself, I don't want it to go to probate. I've got an idea. I'll put my son or daughter on title. I'll own it together with my adult child. That way when I die, they take over, it skips probate. It does skip probate, but let me give you 3 reasons that's not a great idea. Reason number 1 is liability. When you put a son or daughter on title of your home or bank account, they're not just joint tenants, they are now As a co-owner, if they get into a car accident, their dog bites somebody, someone slips on their property, lawsuit, judgment, what can they attach? Anything they own. And they own now half of mom's estate. Imagine this, you put your daughter on title a few years ago. She now discovers her husband, your son-in-law, is cheating on her. She throws the bum out, they divorce. But in the divorce settlement, half of what she owns goes to the ex. I don't want to, I'll just translate. 25% of your equity just left with your ex-son-in-law. Ouch. Here's the point. When you commingle assets with your children, their problems become your problems. They affect your estate. That's just reason one. Here's reason two, distribution. Let's say the three of you in the front row are my three children. I make a deal with my daughter. Look, mom's gone. I don't want the house to go to probate. Let's you and I own it. When I die, I would like you to sell the house and share it with your brother and sister. And she says, okay, Dad, I'll do it. When I die, does she have to? No, she got a house and the two of you got disappointed. I will tell you right now, I'm sorry to break the news, but brothers cheat sisters and sisters cheat brothers. And they justify it. I guess Dad knew I needed the house. No, you didn't do what you said you'd do. Let me make this really clear. I had a plan. It was just a lousy one. Deceased father cannot make her sell, and neither can her siblings. She got a house, and they did not. Let's say I don't have multiple heirs. I have a single heir. I'm giving everything to my daughter. Let's say your daughter named Barbara. So you put Barbara on the house, and you die. Now Barbara owns the house. But watch this. When Barbara then goes to sell the house, she has to pay capital gains tax all the way back to your original purchase price. So let's imagine you bought your current house 20 years ago and paid this, and 20 years later it's worth this. Let's just make the math easy for the speaker. 2 decades, 200,000. You know what 20% of 200,000 is? $40,000 to the IRS in capital gains tax. But listen to this, folks. None of that's going to happen when you pass it through a trust. When you pass your estate through a trust, your children are not co-owners, they are beneficiaries of the trust. As beneficiaries of the trust, there is zero capital gains tax due, none, zero, because everything in the trust when you die goes to the heirs at the current value. It's called a step-up tax basis. Everything goes at the current value, no capital gains. There's no distribution problems with the trust, because if my trust says third, and I die, what's the trust say? Third. It's not negotiable. It's not contestable. Think of the words here. Revocable living trust means while I'm living, I can do what? Revoke my previous instruction. But when I'm no longer living, the trust becomes irrevocable. You know what irrevocable means? Cannot be changed. So I often tell people this: if you do not like what your parents wrote in the trust, when they die, you will have the right to be disappointed. And that's it. You can't change it at that point, okay? So we're going to get to questions at the end here in just a few more minutes, but I wanted you to know, don't fall into that trap of, oh, well, if I just do this, you got to understand there are consequences to decisions, and some are great and some are not so great. So let's talk about, but the last reason this is so much better than joint ownership is the liability. Just because I have a trust today does not mean my daughter cannot divorce her husband. Sure, she could. It doesn't mean my son couldn't drive too fast with his car and injure somebody. Those things can happen. But if those things happen today, those things will affect their estate, not my estate, because we did not commingle the assets. Are you following me? So there might be another way to avoid probate, but it comes with so many downsides. With the trust, I'm literally saying, hey kids, here it is, come get it. No fighting, no courts, no delays, no taxes, no probate. I mean, it's just better in a zillion ways. All right. By the way, Benjamin Franklin, Patrick Henry had trusts. The first trust was written by Patrick Henry, and it was written for Lord Fauquier, Fauquier County, you heard of that? Before the Constitution was signed, trusts were created in the colonies. So this comes back, this is from England. This has been in our culture and in our law for centuries. So I just want you to know, this isn't a new thing, this new trust thing. It's been going on a long time. I do need to talk, I only have a few more minutes left, but I want to talk about getting a trust and understanding sort of the mechanics of the kind of questions that you might want to be prepared for. Some people, let's face it, you can find a lawyer on your own and pay whatever they charge, and it can be a lot of money. And sometimes, in many cases, with most lawyers, when you get a trust made and then you have a question and you call them, what else shows up? a bill. It's called billable hours, and that's sort of sad. Our company charges $0 for ongoing consultation. Once the trust is made, you get a lifetime of ongoing consultation. But you could go to a lawyer. I actually would recommend you find a lawyer to do this. Don't do this on your own. But the other concept besides going to a law firm is you can also go and go to Staples and buy a kit, fill in the blank. Or you can go to LegalZoom.com and create your own documents on the internet. The problem with the kits is there's no attorney guiding you, helping you, answering questions. Nope. It's you with your law degree creating a complex legal document that you hope works. And if it doesn't, you won't be around to see how it turned out. Now, I don't have to say anything bad about LegalZoom, so I won't. But I will read you what they say about themselves. These are their words. I just consider this a warning and do what you want with it. It says, LegalZoom is a document service and not a substitute for the advice of an attorney. It says, LegalZoom is not permitted to engage in the practice of law. Therefore, you will get no advice, explanation, opinion, or recommendation. If you're doing it wrong, they can't stop you. It says, LegalZoom will not review your answers to see that they're legally sufficient. But I love this one. LegalZoom cannot guarantee that the information on our website is current. The law could have changed a couple years ago. I'm just saying you can save some money by not using a lawyer, but I think that's a dangerous thing. So we've got lawyers in our network that help our clients at a very reasonable cost. But let me forget how to get it. Let me just tell you what a good attorney consultation might sound like when we're talking about a trust. Now, I'm not your lawyer. This is not legal counsel. I'll be very careful here. But I'm going to give you a sample of some questions that might be asked, and you're getting a thorough, back and forth. You don't want just, 3 kids, third, okay, we're done, here it is. No, you need some questions. So the first question might be, tell me, when you die, do you want everything to go to your children? Do you want it to go equally? Do you want to give some assets directly to grandchildren, sort of a grandparent gift? What about churches, charities, ministry, Do you want, a good attorney might say, do you want everything to go from the trust to your heirs as soon as you die? Or would you want to leave some assets in your trust for years after your death to fund your grandkids' education or maybe great-grandkids? See, what a lot of people don't know is they just don't know, but you can leave assets inside your trust if you want up to 70 years after you've passed away. Yeah, I do not remember my great-grandfather, but if he left me money for college, I would remember him fondly. No, we have a dear friend of our family, graduated medical school about 10 years ago. He's now a doctor. He's in his mid-30s. He graduated medical school with 0 debt. His grandfather created a trust 30 years ago, and his grandfather's trust said this. Hey, grandkids, listen up. There's money over here, but there is no money for trips and motorcycles. It is for your education. And his trust said, go to the best school you can get into. I am your scholarship. He said, I have not talked to my grandfather in 15 years since he passed. He said, but I thought about him every time my tuition got paid. You know why? Grandpa thought about me 30 years ago. I'm just saying you can be multi-generational blessings. You know what I mean? And I'll be honest with you. I don't think all kids are meant for college. I think this could go to fund your grandkids' education at maybe a better school. That would be better for them in their developing years and not that. So I'm not pushing that. I'm just saying, that's an important thing to think about. The trust gives you some more tools for that. So the attorney and you are kind of hashing out ideas. A good attorney cannot just make a plan, but they must help you develop a backup plan. You know why? We don't know how it ends. Who dies first? I don't know. So the attorney might say something like this. Hey, I see you've got a son and a daughter, and you want them each to get 50%. No problem. But what would you want to have happen in the event you died with your son? Going to dinner, car accident. Would you want his share to go to his sister? Or would you want his share to go to his wife? Or would you want his share to be kept in the trust for his children, your grandchildren? And another question, when would you want it to go from the trust to the grandkids? When they turn 18? Well, you can do that, but they won't have any money at 19. How about 25 or 30? Someone the other day said, keep going. But if you say where, I guess it would go to his kids, but you don't say when. You know when is? 18. You know what an 18-year-old does with an inheritance? Woohoo, college, who needs that? 2 years later, the money's gone and so's the scholarship. Because someone didn't ask a simple 4-letter word, when would you like it to go? We just happen to think 25 is a lot better than 18. Now, I have some clients say, if it does go to the grandkids, how about half at 25 and half at 30? You know, let them make their mistakes, but not on all of it. So my point is, if you're not asked the question, guess what? You don't know to provide the answer. The experienced attorneys we work with, just they know to ask the next thing and the next thing. Like, here's an example. Some people tell the attorney, hey, I don't like my son-in-law. I don't like the way he treats my daughter. This money's not for him, it's for her. And I want to be really clear in the document that if she's not there when I die, her share will go to her children, but not her spouse. And the lawyer will say, not a problem, we can exclude the son-in-law or the daughter-in-law. But a good attorney says, I got one more question. When you say you want your daughter to get her share, but if she's not there, it's to go to her children. When you say her children, did you mean biological children? Because what if later in life she remarries someone who has 3 kids from a previous marriage? She didn't raise them. They were out of the house when she met their dad. But those are her children. The money you thought was going to these 2 is going now to 5. Why? Because you didn't answer the right question. You know what I'm saying? If the question wasn't asked, you didn't know. You know, the biological children or the legally adopted. Are you following me? But if it's not asked, stepchildren are children, foster children are children, but those are not biological. So the right questions provide the right answers. Does that make sense? Now, I talked about LegalZoom. There's other kits out there, you know. Let's say I got a kit and it says special instructions. Ooh, honey, listen to this. Let's leave some money for the grandkids' education. I heard that at a workshop. $70,000 will be set aside for the grandkids' education. All right, that'll get them started. My son reads this and goes, woohoo! My grandson, when I die, gets, oh man, there's money in a trust for my education. Woohoo! I'm going to jet ski school in Florida this summer. Well, that is not what I meant, but it says education. He wants to learn how to ride a jet ski. It's called Sea Do You. A good attorney would say in the process, Daniel, when you say the word education, did you mean an accredited college, a university, a trade school, a law school, a medical school? And you know what I'd say? Yeah. You go, well, we better write that. Or it could be Joe's fishing school in Alaska. He had a really good week, but we were thinking college. The right language gets the right results. Vague language is vague results, precise language. Are you following me? You know, we have to ask questions that you may have never heard before. If I met you today, I go, oh, do you have any biological kids? No one would talk like that. Lawyers have to ask questions like that because we don't want this to kind of go like you want it. We want it to go precisely the way you want it. So that's where it's not an interrogation. We are talking about things that sometimes that we hope never happen, like kids dying before us. But we have to ask the questions so that this isn't surprised. There's no surprises here. If that, then them. And if they're not there, then this person. If that doesn't work, are you following me? So we take you down, I won't say rabbit holes, but different trails that might happen and come up with scenarios so that this is complete. And, you know, so that's important. Real quick, let me give you the real key. How does the trust avoid probate? You might say, well, one is a set of instructions, a will, and a trust is a set of instructions. How come the trust avoids probate and the will does not? The short answer to that question is the Commonwealth of Virginia and other states say if you own more than a certain amount, your estate triggers probate. So how do you avoid probate? Don't own that amount. When we create a trust for you, you are the trustees of the trust. We retitle your assets, some of them, into the name of the trust. Now the trust owns the assets and you do not. But the assets are in your name as trustee, not as owner. Are you with me on the difference? So when my wife and I signed our trust 24 years ago, we then signed a transfer letter telling the county to change the deed. The deed of our home went from Daniel and Christy Leonhardt, the owners, to Daniel and Christy Leonhardt, the trustees. It's still our house. We still live there. We still pay the taxes, still pay the mortgage, mow the lawn unless my son comes over. The truth is nothing changes. You're just a trustee. I still have checks. I write checks. I still slide my card at Subway and they give me a sandwich. The money's mine. The house is mine. It's just in the trust. Are you with me on it? It's a concept. I'll give you a kind of an analogy. The trust works like a safe. When you put something in a safe, is it still yours? Can you get to it? Can you put something else in there? The safe is the housing that protects the valuable from threats, fire, flood, thieves. The trust is the housing that protects your assets from probate. Let your asset, now the house I put in there 24 years ago, 3 years later I sold it and bought another house in the name of the trust. We told the title company, we want to take ownership as Daniel and Christy Leonhardt, trustees of the Daniel and Christy Leonhardt Trust. So we bought that house in the name of the trust. We've refied that once or twice. Then we sold that house, and our current house is in the name of the trust. So just remember, having it in the name of the trust is putting it in the safe. But a real quick story. I did a meeting in Midlothian. You know where that is, near Richmond? Lady comes up after the meeting. Daniel, my father had a trust. He died. I had to take everything to probate. Took a year and a half because nothing was in the name of Dad's trust. He created it. He shoved it in a drawer, signed it, shut a drawer, but he kept his name on the house, his name on the accounts, not the trust name, his name, and it all had to, because he owned more than 50,000, triggered the probate. And I said to her, I don't want to rub salt into your wounds, but it's kind of like your dad bought a really nice safe and then put the jewelry on top. It doesn't matter how strong the safe is, folks, if there's nothing in it. It doesn't matter how well written the trust is if there's nothing in it. So, very important document. I'm going to cheat and take one more minute to tell you one more thing. Then we'll stop for questions. But I do want, because time is I'm under constraints. But you can stay as long as you want and ask questions or listen to questions. But I'm supposed to tell you at 7:30. But let me tell you one more thing. This is not my trust. Mine's at home, but it looks like this. If I were to have a heart attack this evening and taken to an emergency room and my kids show up and go, how's Dad doing? And the doctor says, he's stable, but he's unconscious. We need to do surgery. Which of the two of you kids has the power of attorney for health care? I need someone to sign off on the surgery. And my daughter says, I think that's me. And you know what the doctor says? I think that's not good enough. I have to see the documents. So the kids have to leave the hospital and go to my house and try to find them. Geez, where does Dad keep this stuff? It's as messy as when I lived here. Oh, great, there's a safe. Do you know the combination to Dad's safe? I don't. I kind of play that out like, what if you took the time to make this, but when you need it, there's a glitch. That'll never happen to me. Or our clients, we create a card for you that gives you, it says emergency access to the medical directives. And each spouse gets one. The card tells the doctor, if you're unconscious, your name, the name of your power of attorney, the alternates, phone numbers to reach them, the name of your doctor. It tells them you're allergic to penicillin or sulfa medication, or that you have a medical condition like diabetes or asthma. It also gives them the HIPAA release. You know what that is? So they can speak freely to family. But not only that, before they roll me in the OR, the nurses at the nurses station will go to this website, punch in this code, and right on the computer at the nurses station, they will see my powers of attorney and my advance directives signed and notarized, and they'll just print them right there. No one has to go home and look for them because they're in our wallet the whole time. So, folks, you won't find this when you just go to every attorney, but those that do estate planning. Let me stop and take questions. I know you've got questions, and it's 7:34 or something. Sorry about cheating there, but if you need to go get kids, he said that I could have till 8 with you, but that's as long as you want to stay. You're free to leave at this stage. Let's take a question or two, or let's start here.
If you have farmland that is broken up to begin with from their parents' estate, and one sibling may have a living trust and the other two don't, how do you figure it out?
Well, when you create a trust, you can either put 100% of a property in or your percentage of a property. So if you own a third with your siblings, you could put 1/3 of the property in this trust. That way it doesn't automatically go to the others. It would go to your share, to your trust, to your beneficiary. So yes, yes in the back, sir. Great question. Great question. Let me explain. When we do what's called the funding of the trust, that's the retitling of assets to the trust name. Think of that as opening the safe and putting something in it. We sit down with the client, sign and notarize, and then we transfer their real estate, because that definitely has to go. But you have other assets, and we'll tell you, here's what you show the bank. That'll tell the bank there's a trust, and they will make your existing accounts trust accounts. So the checks and stuff will be, you don't get new checks. You don't get a new debit card. The bank will recognize your existing accounts as trust accounts. Are you following me so far? But you mentioned IRA. We will tell you, you cannot retitle your IRA. We tell this to our clients when we're sitting in front of them, signing and notarizing. You cannot retitle your IRA into the trust. If you did, the IRS could make you pay all the deferred taxes this year. So we will tell you, some things have to go in the trust and some things cannot right now go. The things that we will tell you to keep in your name: IRAs, 401ks, insurance policies, some government pensions like a TSP, those will stay in your name. But all of those things that stay in your name have beneficiaries. Are you following me? They're not going to probate, they're going to somebody. We will recommend that you change the beneficiary to the trust and let it go through the trust. Now listen, if you are married and it's an IRA, your spouse will always be first for tax reasons. But the trust should be second, not the children. Now someone might say, well, Daniel, why do I need to change it? I already have spouse and then children as alternates. Great question. Let me give you an example why you don't have to change it, but why you're going to want to change it. Let's say I have an IRA and you're my 4 kids. My wife, your mother, has passed. It's a dad with 4 kids. And the life insurance policy is $400,000. You are all named as beneficiaries at this moment. I should change it to the trust, but I didn't. I left it in their names. My son and I are going to dinner, car accident, we both die. Where's the money go? To the remaining beneficiaries, third. And I just disinherited his children. They not only, think about this, they not only lost their dad, they lost their grandpa, and they just lost their inheritance to their uncles and their aunt. But if I name the trust as the beneficiary, what happens? 400,000 goes to the trust. From the trust, it goes to my 4 heirs. That's what the trust says. But the trust says if he's not there, his share goes to his children, not to his siblings. Are you following me? The trust knows what I want. So you're still getting your 25%, but his 25% is going to his children. If there are none, then you might get 30. Are you following me? But the trust is not going to disinherit them. One more thing, because it went through the trust, if his kids are under 18, they don't get the money till they're 25, because the trust says no distribution to minors, or a minor is considered still a minor till 20, whatever number you choose. But most of our clients like the 25. Hold on, one more step, I'll get to you. The 4 of you, you're not in yet. The 4 of you are my 4 kids, sorry. Don't worry, you all survived this time. A $400,000 life insurance policy, you're all named as beneficiaries. I should change it to the trust, but I didn't. I left you on there. I died and you each got a check for $100,000. He enjoys the money, he enjoys the money, he enjoys the money, but she does not. And the reason your sister doesn't enjoy her $100,000, she's in the middle of bankruptcy. Anytime she gets any money, it has to go to the creditors. Not as much fun as her brothers, but watch this. If I name the trust as the beneficiary, what happens? I die, $400,000 goes to the trust. The next day, the boys go to the bank, book the cruise, whatever they're going to do. But their sister here is going to say this: I don't want my $100,000 right now. I'm going to leave it in Dad's trust until the bankruptcy's over. I will take it in a few years with interest. But guess what? If it shows up in her name, it could be lost to that. She might say, God forbid, and I'm not using you, she